I welcome you all back once again to our channel, and this is Advocate Frederick. This session is part 5 of our target to complete 50,000 multiple choice questions in law for all your legal exams. Questions are framed in English, and explanations to each question will be displayed in the following slide. Pause for a while, read, and move to the next question. Explanations carry much content which are expected in the upcoming examinations as well. If you haven't seen our first 4 parts of this session, I request you to visit our channel and see it as well. And if you haven't subscribed to our channel, I request you to subscribe to it, as we will be completing 50,000 multiple choice questions which would be probably asked in the upcoming law examinations which are to be held in various states in India. So without wasting much of a further time, let's move to the first question. Under which one of the following provisions of the Civil Procedure Code 1908 can an ex parte decree be set aside? Order 9, Rule 7, Order 9, Rule 11, Order 9, Rule 13, Order 9, Rule 12. I'll give you 3 seconds to think about the answer, and if you're not sure about it, I'll give you the answer. Okay. So the answer for this question is option C, Order 9, Rule 13. The explanation will be in your next slide, whereas I have given you the explanations for all the options which is in the previous question, so as to give you a clarity on what the rule or order says or what the section says. Okay, so our answer to the question was Order 9, Rule 13. So Order 9, Rule 13 of CPC specifically provides for setting aside an ex parte decree if the defendant satisfied the courts, the summons was not duly served, or he was prevented by sufficient cause from appearing when the suit was called on for hearing. So basically, an ex parte decree is given wherein the defendant does not appear on the summons, or if the summons had not been served properly and the defendant has not been able to appear, an ex parte decree is served. Thereafter, if the defendant wants to reappear on the case, there needs to be an application which needs to be filed along with the defense. So the setting aside application should needs to be filed under Order 9, Rule 13 of CPC along with the written statement. Moving ahead to the next question. Decree under the Civil Procedure Code 1908 has been defined in its Section 2, subsection 1, Section 2, subsection 2, Section 2, Clause A, Section 2, subclause B. So the correct option is option number B, Section 2, subsection 2. So subsection 2, subsection 2 of CPC defines decree as a formal expression of an adjudication, which, so far as regards the courts expressing it, conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit. So basically, the key points for your consideration to understand what a decree is a formal expression of the adjudication, a conclusive determination of the rights of the parties, and it must be in a suit, and the decree can be either preliminary or final. Section 144 of CPC states that restitution or also decrees and rejection of a plaint and determination under Section 144 CPC are also decrees under CPC. So these two are not included as a decree. Usually they ask it as options. So any adjudication from which an appeal lies as an appeal from an order. So an appeal from an order. So it is not a decree. And any order of dismissal for default is also not a decree. So a rejection of a plaint amounts to a decree, but a dismissal for default is not a decree. Okay. Moving ahead to the third question, Section 11 of the Transfer of Property Act 1882 will be applicable only when the interest transferred in the property is limited, absolute, both A and B, none of the above. So the correct option is option number B, absolute. So there is a absolute interest which is transferred in the property under Section 11 of Transfer of Property Act 1882. So Section 11 of TPA says about restriction which are repugnant to the interest created. So it states that when an interest in property is created absolutely in favor of a transferee, but a condition is imposed that restrains him from disposing of it, then such a condition is void and the transferee takes the property as if no such restriction was made. So this section basically aims to protect the right of the absolute parties ownership of the transfer. So therefore, it applies only when the property is transferred absolutely. If the transfer is limited, like life estate or a leasehold, then the restrictions on enjoyment can be valid because the transferee never got the absolute ownership of the in the first place. Moving ahead to the fourth question. Section 36 of the Transfer of Property Act 1882 is related to the doctrine of election, doctrine of Cyprus, doctrine of acceleration, doctrine of apportionment. I'll read the options again to you. Doctrine of election, doctrine of Cyprus, doctrine of acceleration, doctrine of apportionment. So the correct answer is Section 36 of the Transfer of Property Act 1882 is related to doctrine of apportionment and the option is D. So Section 36, it deals with the apportionment of periodical payments on transfer of interest. It states that when there is a transfer of property in which an interest exists, so interest means likely a rent or annuities or dividends or maintenance. So when you transfer a property and there is an interest like rent or annuities or dividends or maintenance which exists on the transfer, such payments shall be deemed to accrue from the day to day and are apportionable accordingly. So the apportionment is day to day and it is transferable as well. So the transferee is entitled to the benefit of such apportionment after the date of the transfer. For example, there is a sale deed which is executed by one party to the other, and there are interests like annuities, rents, or dividends or maintenance which accrue from the said property which is transferred through a sale. So such apportionment of those benefits also accrue to the person who received it from the date of this transfer only. Okay. Suppose X transfers property to Y on 15th June. The property earns 12,000 annual rent payable on 30th June every year. Under Section 36, the rent is apportioned. So I request you to read the example for a minute so that you will get a better understanding. Moving ahead to the next question, question number 5. Under Section 49 of the Transfer of Property Act 1882, the transferee is entitled to the benefit of insurance covered against the loss or damage by fire, encroachment, natural calamity, none of the above. So your correct answer is fire. So when in case a transferee has been transferred a property and the property or the transferred property has been damaged under the Transfer of Property Act. So the benefits of insurance are covered under Section 49. So which kind of damage or loss does Section 49 of the TP Act cover? So the loss or damage is fire, through fire. So if the transfer of the property has insured the property against any loss or damage by fire, then after transfer, the transferee, the person who acquires the property through the sale or any transfer, is entitled to the benefit of such insurance, even though the insurance has been put by the person who transferred the property. This section prevents the transferor from unjustly enriching himself by collecting insurance money after transferring the property. Sometimes what happens is that a person insures a property and he transfers it to some other person. Thereafter, the transferred property gets into fire, and after which the person who transferred the property to the transferee claims ownership of the insurance amount. So avoiding this circumstance to happen, Section 49 has specifically stated that unjust enrichment by the transferor himself on loss or damage due to property is avoided in such circumstances. So, moving ahead to the next question. Question number 6. The codes of small causes under under Section 3 of the Civil Procedure Code 1908 are subordinate to which of the following? So the courts of small causes are subordinate to which of the following? High Court only, District Court only, neither A nor B, both A and B. So we know that the courts of small causes are the lowest grade of courts in India, and these courts are mentioned under Section 3. So it also mentions that these courts are subordinate to the High Court and the District Court. Okay, so both A and B are correct answers to this question. So have a read of it. Moving to the seventh question. Which one of the following is a transfer under the Transfer of Property Act 1882? So the Transfer of Property Act basically states what is a transfer and what not is a transfer. So charge, petition, transfer of a debt, surrender. So which one of the following are examples of a transfer? So the correct answer is option number C, transfer of a debt. Debt are loans that we get from a party who credits. So the creditor grants loans to the debtors, and the loan granted by the creditor to the debtor is known as a debt. So such debts, such loans are transferred. So such transfer of a debt is also called as a transfer of property. Okay. So partition and surrender are not transfers. They are just adjustments of existing rights. And a charge is only a security interest, which is not a transfer. But transfer of a debt is an actionable claim. So when I say it is an actionable claim, it can be sued. Okay, the property which is transferred, that is a debt, can be sued and it is actionable. So it is specifically recognized as a transfer under Section 130 of the Transfer of Property Act 1882. Moving ahead to the next question, question number 8. Under the Transfer of Property Act 1882, sale is a transfer of. So when you sell some property to another person, so which kind of transfer is it? Is it a transfer of an interest in a specific immovable property? Or is it a transfer of a right to enjoy the immovable property? Or is it the ownership which is transferred? Or none of the above? Or is it something different? So the correct option is option number C, ownership. So when you transfer a property through a sale deed or a sale agreement, you effect a sale agreement, and within a period of 1 month or 3 months or 90 days, whatever may it be, so you execute a sale deed thereafter. Then you transfer the ownership, basically. Okay. So the option is option number C. Ninth question, Section 37 of the Transfer of Property Act 1882, which deals with the right to proceeds or revenue compensation, is based on. So Section 32 basically deals with the right to proceeds or revenue compensation. So under which doctrine does Section 37 apply or based upon? So doctrine of contribution, doctrine of election, doctrine of apportionment, doctrine of substituted security. So the Transfer of Property Act itself is a doctrine of apportionment. But specifically, Section 37 of the TP Act, it deals with proceeds and compensation, right? So when I say proceeds, it relates to an amount which has been generated through something. And when I say revenue compensation, there is something which is rewarded as a part of revenue, some financial gain through compensation. So election, apportionment, so you don't transfer any position or ownership. So there is no apportionment there. There is no doctrine of election, no substituted security. So the correct answer is option A, doctrine of contribution. So I have given you all the four doctrines in the explanation part as a table, and under which section of the Transfer of Property Act does each of these doctrines apply, and the core idea behind the doctrine. So basically, the doctrine of contribution is under 37, as we see in the question. So the core idea behind it is that there is a share of the burden of common charge. So the proceeds or the revenue contribution is shared between members who are part and parcel of the property. Okay, so there is a fair distribution of the liability which needs to be undertaken by the parties. In the doctrine of election, section 35 deals with the doctrine, whereas the core idea is they choose between the benefit and the property. So one enjoys the property and the other benefits the property. So the rental proceeds or any interest which may accrue from the property may be enjoyed by one person, and the property's possession may be enjoyed by another person. So this concept is known as the doctrine of election. So in this situation, both cannot get by the same person. It needs to be divided between two people. And apportionment is they divide the payments periodically on a fairly basis. For example, few interests or like rent, annuities, dividends, or any maintenance which may accrue from the property should be equally divided periodically between the parties who own interest in the property. Substituted security is dealt under section 73 of the same act, and it means that the security shifts to the compensation. So it basically protects the mortgagee from not losing the amount which he mortgaged for. So I have discussed all the four doctrines in detail in the explanation part. I request you to pause for a while, read the four doctrines in brief, because I have given you examples as well with respect to each of the doctrines. So these doctrines are usually asked multiple times in various examinations. So have a thorough reading of it and move to the next question. So this is the doctrine of apportionment and substituted interest. Moving ahead to the 10th question, which one of the following order of Civil Procedure Code 1908 is related to issue commission? Commission. Order 24, Order 26, Order 25, and Order 27. So the correct option is Order 26. Option number B, 26. As you can see, Order number 24 deals with payment into the court by the defendant, 25 with security for costs, and 26 with commissions like the examination of witnesses, local investigation, scientific investigations, and accounts and partition. And Order 27 of CPC deals with suits by or against the government or public officers. Moving ahead to the 11th question, Section 10 of the Civil Procedure Code 1908 does not apply when the provision previous suit is pending. So when a previous suit is pending, Section 10 states that the CPC does not apply. So when there is a suit already pending in a court, okay, Section 10 states that the CPC does not apply. So where is the suit pending? So where a suit pending, the Section 10 of CPC does not apply. So it is in a foreign court. When a suit is pending in a foreign court, CPC does not apply under Section 10. So Section 10 states the doctrine of res sub judice, as we know, and Section 11 states about res sub res judicata, right? So Section 11 states about res judicata and Section 10 states about res sub judice. So what does it say? It bars the courts from proceeding with the trial of a suit if the matter in issue is directly or substantially the same in a previously instituted suit between the same parties and is pending in a competent Indian court. So the objective is to prevent two courts from simultaneously trying the same matter and avoid conflicting decisions. If the previous suit is pending in a foreign court, Section 10 does not apply, as Section 10 applies only if it is instituted in a Indian court, competent Indian court, not in a foreign court. So Section 10 does not apply. The Indian court is not bound to stay the proceedings. However, the court may, in its discretion, consider the principle of Comity of Nations. Moving ahead to the 12th question. Under the Transfer of Property Act 1882, the remedy of foreclosure is available under which one of the following mortgages? So, foreclosure is one of the remedy under the Transfer of Property Act in case a mortgage is done. So, foreclosure, the little meaning is that, so when you mortgage a property, you get in return a loan or an amount from the other party, mortgagee, right? So if you want to foreclose in the sense, if you want to repay the default, if you want to repay the debt and get your mortgaged security back, you can foreclose it prior. You see, if you tend to put a period of 3 years, within 3 years, you can repay the amount and get back the mortgage property. And you foreclose it, you previously paid. This setup, this remedy is available under the transfer of property. Under which one of the following mortgages? So, this remedy is not applicable to every mortgage under the TPA Act. Mortgage by conditional sale, English mortgage, usufructory mortgage, simple mortgage. So, mortgage by conditional sale. So, foreclosure, it is a remedy available to the mortgagee where he can seek or ask the court to debar the mortgager from redeeming the property. After foreclosure, the mortgager's right of redemption is extinguished. So, the foreclosure under the TP Act states that a mortgager who mortgaged the property is now extinguished of his redemption of the property, whereas the mortgagee has a specific right to apply to the court to debar the mortgager from redeeming the property from the mortgager. So this concept of or the right which is available to the mortgagee is known as the foreclosure under the TPA 1882. So section 67 of 1882 Act states that foreclosure is allowed only in certain types of mortgages, mainly mortgage by conditional sale under section 58 clause C. So the mortgage by conditional sale is mentioned under section 58 subclause C, whereas when it can be mortgaged through foreclosure is mentioned under section 67. So we need to know what is a mortgage by conditional sale. So in this situation, here the mortgager ostensibly sells the property on condition that if he repays, the sale becomes void, otherwise it becomes absolute. Foreclosure is the appropriate remedy because the transaction looks like a sale. And English mortgage is mentioned under section 58E, which is known as remedy by sale of property, not foreclosure, and usufructory mortgage are mentioned under section 58, subclause D. Whereas mortgagee has a remedy by possession and usufruct. Usufruct means enjoying the rents of the profits, rents or profits. The benefit which is gained from the property is being enjoyed. That is known as usufruct. And a simple mortgage is mentioned under section 58, subclause B. Here the remedy is by sale of the mortgage property, not foreclosure. The mortgagee simply sells the property and there is no foreclosure part. There is no application to the court to debar the mortgager from redeeming the property. Such transactions don't happen here. So moving ahead to the 13th question. The case of Jayadayal Podar versus BB Hazra. Jayadayal Podar versus BB Hazra is related to which of the doctrines mentioned below? Doctrine of election, doctrine of part performance, transfer by unauthorized persons, ostensible owner. So your correct answer is ostensible owner, option D. If you find my video or this session little bit slow, you can fast forward it to 1.25 or 1.5 for your convenience. And if you find it little fast, you can switch between the slow mode 0.75 on your settings. Moving ahead to the next question. Question 14. An agreement to develop Chabahar in Iran as an international transport corridor was finalized to which of the following countries? So this agreement of Chabahar in Iran. So this is a GK question, general studies question. So the agreement was between India, Afghanistan and Iran. So why was this port developed? Because see, from India to trade with Afghanistan, we have to either go through the route Pakistan. So to forego the route, the Indian government with an agreement with Afghanistan and Iran has developed this Chabahar port. Whereas the Chabahar port is in Iran and this route specifically gives India a chance to trade with Afghanistan bypassing Pakistan. Okay. Moving ahead to the 15th. Under the Transfer of Property Act 1882, which one of the following properties may be transferred? An easementary right from the dominant heritage, mere right to sue, right to future maintenance, actionable claim. So your correct answer is option D, actionable claim. So the section 6 of the Transfer of Property Act 1882, it lays down what may be transferred and what may not be transferred. So non-transferable properties are easementary rights. So when I say easement, the common pathway could be an easementary right between two people. So an easement is attached to the dominant heritage and cannot be transferred separately. Mere right to sue. See, a person has a property. In case I have a property which is in my name and my ownership, I just give the right to sue to some other person. Then such kind of transfers cannot be made under the transfer of property. Only I can sue on my behalf. On my behalf, I cannot make someone sue for me, so it cannot be transferred. This is mentioned under section 6, subclause CE. Right to future maintenance is mentioned under section 6 DD and it is also not transferable since it is a Personal right. You cannot transfer personal rights to anyone. What are transferable or actionable claims, which are mentioned under section 3 plus section 130. So when any part of the explanation says plus, it means that you have to read section 3 along with section 130. Then only you get the clear definition of what is transferable and what is not. So a claim to an unsecured debt or a beneficial interest in immovable property not in possession is transferable. Moving to section question 16. On which date India rectified? Sorry, it is ratified. So ratified is uh, putting into the application of an international convention. So the international convention in any conference, for example, the conference at Paris or a protocol at Kyoto. So such kind of conferences frame conventions. So there are various conventions. For example, the question that we see on the screen is for nuclear damages. We have various conventions on biodiversity, ozone depletion, water convention, hazardous waste conventions. So one such convention is the Convention on Supplementary Compensation for Nuclear Damages of 1997. So India ratified it on which date is the question. So it ratified it on 4th February 2016. This is a older current affair question, but still it is a fact. Moving ahead to the 17th question, which one of the following countries has become the 35th member of the Missile Technology Control Region? So this is also a question which is part of the general studies. 35th member. So India is now a member of the Missile Technology Control Region. Next question, 18. World Refugee Day. So at times in general studies, they ask these kinds of days, right? World Environmental Day, World Humanitarian Day, World Refugee Day, World Leprosy Day, International Youth Day, Indian Youth Day. Okay. Yuvedvas, right? So the World Refugee Day is observed on 20th of June. Every year, 20th of June. Moving ahead, 19th question. Under the Transfer of Property Act 1882, when can an unborn person acquire vested interest on a transfer for his benefit? So, an unborn can get a vested interest upon his birth. Only on his birth he can get a vested interest. So, an unborn is considered capable of acquiring property. So, provided the interest is limited to take effect after the birth. So this is mentioned under section 13 of the Transfer of Property Act. Moving to section 20, question 20, which one of the following sections of the Transfer of Property Act says that a transfer of property may be made without writing in every case in which a writing is not expressly required by law? So transfer of property is made written in usual situations, but when it is expressly stated by law or which is not required by law, it can be oral as well. Such situations, so the line under the Transfer of Property Act is mentioned under section 5. So not all property transfers need to be written or documented. So it clarifies that, section 5 clarifies that unless some other law specifically requires a written instrument like a sale of immobile property under the Registration Act, then the property can be orally or by delivery of possession be executed. There is no need for transfer of property. So for a sale of an immobile property, it needs to be registered, right? So that is when it is legally accepted as transfer. But in certain situations, any other law, if it specifically requires a written instrument, then it needs to be written. If it does not require it to be written, then it can be oral or by delivery of possession as well. Okay. So they have given you examples in the question, in the explanation. Transfer of mobile property like goods or a chattel can be oral. So I request you to pause for a while, read it, and move to the next question. Question number 21. Which one of the following organs of the United Nations performs legislative functions? So this is a general studies question. So the General Assembly organs the United Nations perform its legislative functions. Moving ahead. 22. Author of De Jure Belli Act Passes. So who authored this particular book? So is it Hobbes, Bentham, Grotius, or Austin? So your correct answer is Grotius. It is not much important in the exam point of view, but still it deals about law of war and peace. So I have given it to you in the question because I have read this book and I found it very useful. So if you have spare time apart from your normal course of work, I request you to download the version which is there online, or you can buy the book and read it. It's a good piece of work by Grotius. Moving ahead to the 23rd question. Under the Transfer of Property Act 1882, A transfers rupees 5,000 to B on a condition that he shall marry with the consent of C, D, and E. Then E dies, B marries with the consent of C and D. Is the marriage valid, invalid, voidable, or void? So your correct answer is valid. See, E dies. A and B they involve into a condition that only with the consent of C, D, and E, the marriage should happen. Now E dies, right? B marries with the consent of C and D. So C and D are the remaining people who are there. So once C and D approve the marriage, they consent to the marriage is valid. Next question. Question number 24. According to Section 3 of the Transfer of Property Act 1882, instrument means instrument. Is it a testamentary instrument, non-testamentary instrument, both A and B, none of the above? Your correct option is option B, non-testamentary instrument. So to understand what a testamentary and non-testamentary instrument is, I have given you the meaning of it. So the non-testamentary instrument is executed during the lifetime of the transferor to transfer of property immediately or in future. So a testamentary instrument is like a will which is made or governed by the Indian Succession Act and not by the transfer of property. So upon the death of an individual, the transferee is then transferred to another person through the will, through a testator, through an appointed testator. So non-testamentary instruments are during the lifetime of the transferee, transferor to the transferee of transfer of property under the Transfer of Property Act under Section 3. Moving ahead to question number 25, we are in the mid of our session. A member of the United Nations can be suspended from exercising the rights of membership by, again, a general studies question. Option A, the General Assembly, Security Council, the Secretary General, the General Assembly on the recommendation of the Security Council. Not much important for your legal exams, but still, yes, you may come across such questions. Option D is the correct answer. Moving ahead, 26. Which one of the authority of the following is entitled with the task of enforcement of the judgments of the International Court of Justice? So this is a international law question. So the answer is the Security Council of the United Nations. If you want to know more about this, just pause it and read it. Question 27. A state is admitted to the membership of the United Nations by the General Assembly after approval from the Security Council. Option B is the correct answer. 28. The Nehru-Liaquat Pact between India and Pakistan was signed in 1950 to resolve the issue of protection of minorities, the accession of princely states, the border disputes, the problem of refugees. See, I have inserted such types of questions into your session because there are situations where your question paper might be difficult. So, in such difficult circumstances, your questions will look like this. You may not know such pact at all because it relates to um, agreements or pacts which happened during the early independence time or during the independence period. So, such pacts are very important to understand the legal nature of the India's legislative uh, protection or importance given to each of the situations during that period. So, the correct answer is the protection of minorities. So, the Nehru-Liaquat Pact, also known as the Delhi Pact, which was signed on 8th April 1950. 29. Where and when was the Urja Varta 2025 event held? Urja Varta. It is a current affair wherein current affairs are here and then asked. So it was held in New Delhi during July 2025. And the other events which were in the options are also mentioned. Just have a look at it. Question 30. Which one of the following articles of the UN Charter relates to the domestic jurisdiction? Domestic jurisdiction under the UN Charter articles. Article number 2, sub article 7. Moving ahead, 31. Which one of the following is essential for a valid contract under the Indian Contract Act of 1872? Very important question. Meeting of minds of the parties, meeting of the parties for searching legality of rights, meeting of the parties to discuss consideration, meeting of the parties to discuss proposal and acceptance. So your correct answer is meeting of minds of the parties. So the essence of a contract is valid when both the parties agree to the same thing in the same sense. So this agreement is in intent is called as the consensus ad idem. So consensus ad idem is a legal maxim, Latin maxim. So it basically means meeting of minds. So to effect a contract, there needs to be two members or two or more parties to the contract. And meeting of minds is one of the most important part of Indian Contract Act to execute a contract. Question 32. The action required to carry out the decision of the Security Council for maintaining of international peace and security shall be taken by all the members of the United Nations or some of them as the Security Council may determine. So the relevant provision is under Article 48 of the UN Charter. Moving ahead, 33. An agent at the time of making a contract does not disclose the name and address of this principal, but it comes to the knowledge of the second party afterwards. In this case, a claim can be brought against whom? Either the principal or both the principal and the agent can be sued. So the agent, the principal is liable for any act or omission done by the agent. So either the principal or both the principal and the agent can be sued in such circumstances as the name and address of the principal was not mentioned. So if the other party could have known the name of the principal or the address, he would have not got into the contract at all, right? So he knew about it later period of time. So both are liable or the principal is liable. The court may leave the agent, but the principal is liable. Joint liability is there, like a partnership. Next, question number 34. Under the Indian Contract Act 1872, A promises B to drop a prosecution which he has instituted against B for robbery, and B promises to restore the value of the things taken. The agreement is invalid or void, and why? So the answer is void. See, A promises B to drop a prosecution. Don't prosecute, just drop it, which he has instituted against B for robbery, which is done, and B promises to restore the value of the things taken. So B gives back the property. He promises to give back the property which was stolen or robbed from A. Now, the agreement is invalid or void? It is void because the act is done against not alone A but against the state. If it is a personal act which involves only two persons, then it can be either valid or void based upon the law which is determined in the Indian Contract Act. But an agreement to not to prosecute against B in case he robbed something from A, so such agreements are void because it is a crime which is done against the state, not against an individual. So an agreement to compromise a criminal prosecution for reward is void. So the law cannot enforce such agreements based on illegal acts. Moving ahead, question number 35. The first arrest warrant by the International Criminal Court was issued in 2005. This is just a fact which you just need to know as a legal person. Next, moving ahead, question number 36. Point out the correct item. There may not be a contract without consideration if, so this is a line which is there in the Contract Act. So there may not be a contract without consideration if the agreement is in written and registered, the parties to the agreement are near relatives, a promise is made to pay a time bar debt. So the correct answer is all of the above. Option D is the correct answer. So here are the exceptions of agreement without consideration is generally void. 37. A contract over the telephone becomes complete at the place where acceptance is heard. In which case was this held? Bhagwan Das versus Girdarial, Girdarilal. Carlyle versus Carbolic Smokeball Company. Maheri Bibi versus Dharmodas Ghosh. Satyabrata Ghosh versus Mugniram. So your correct answer is Bhagwan Das versus Girdarilal. So I have given you the facts of the case and the legal principle involved in this case and the significance in the telephone industry. 38. Match list 1 with list 2. So the list 1 contains the concepts and the list 2 contains the case with respect to the concept. Each concept may be even asked individually in your examinations. So I want you to match it. So even if you know one of the lists, or you may be able to answer everything. So we all know that the commercial contracts comes under the case involved is Gagan Saran versus Ram Hardiship Charan Ram Gopal. So this is a famous case, and Hyde versus Wrench was also a famous case. So it relates to damages for in-search breach. So our option is option number D, 3124. Moving ahead. Question number 13. Which of the following cases belongs to the principle of pari Pari delicto. Barrett versus Irwin. Banwarilal versus Sukhdehan Dayal. On Carmel versus Banwarilal. State of Madras versus Gannon, Dinkerle and Company. So your correct answer is Barrett versus Irwin. Pari delicto. So what does this principle state is that when both the parties are equally at fault, okay, the court will not assist either party. So I am also at fault and you are also at fault. So the court, even if sued by both the parties, the court will not assist either of us. Okay, so the court will not assist either of the parties. So the complete maxim is that in pari delicto, potior est conditio defendatis, which means when both the parties are equally at fault, the court will not assist either party. So this principle applies when the contract or transaction is illegal or immoral and both parties are involved in wrongdoing. Moving ahead, 40. Under the Indian Contract Act 1872, if the nature of liability in a contract is changed, it is called rescission, renovation, alteration, novation. So a correct answer is novation. So I have given you the meaning of what is novation and all the other options, rescission, renovation, and alteration as well. Moving ahead, 41. Under the Indian law of contract, consensus ad idem means we already saw what is consensus ad idem. Meeting of minds, right? So our correct answer is to agree on the same thing in the same sense. So option A is the correct answer. Next question. So the question is slightly wrong. In case, okay. In case of breach of contract, the principles for assessment of damages are given. Hyde versus Wrench, Hadley versus Baxendale, Scoff versus John Dine, Scoff versus John Dine, Carlisle versus Smokeball Company. So your correct answer is option number B. Moving ahead. Question 43. An agreement which is enforceable by law at the option of one or more of the parties, but not at the option of the other, is valid contract, voidable contract, void contract, none of the above. Your correct answer is option number B, voidable contract. So one party has the right to enforce it and the other may choose to avoid it. Usually arises due to fraud, coercion, undue influence, or misrepresentation. 44. When both parties to an agreement are under a mistake, as to a matter of fact essential to the agreement is voidable, void, illegal, none of the above. So when both the parties are under a mistake as to a particular fact which is essential to an agreement, then such kind of agreements are void. Option B is the correct answer. 45. Under the Indian Contract Act 1872, an agreement not enforceable by law is said to be void. Which one of the following agreements is not void? So as we know that the Indian Contract Act 1872 states that an agreement which is not enforceable by law is said to be void. So an agreement to be enforceable has to be warranted by the Indian Contract Act. Am I right? So which contract is or an agreement is not void? So here three are void and one is not void. So an agreement in restraint of legal proceedings, an agreement in restraint of trade, agreement under coercion, agreement in restraint of marriage. So your correct answer is option C, agreement under coercion. So the explanation gives you what is a void and voidable contract. So voidable is at the option of the aggrieved party. Void is not enforceable at all. Moving ahead. Question number 46. A lends 1 lakh to B and B promises to repay it with interest at 12% per annum after 1 year. The agreement also provides that if the amount is repaid within 6 months, the rate of interest will be 10%. So with the reduction in time of repayment, the rate of interest is reduced by 2%. So such kind of stipulation or condition is valid, void or voidable or illegal. So such kinds of agreements or stipulations or conditions under the agreement or contract is absolutely valid. Option A is the correct answer. So there is no prohibition under the Indian Contract Act for conditional interest rates. You can reframe the interest rates. Okay. Question 47. Under the Indian Penal Code 1860, which of the following sections deals with abetment of suicide of a minor or a person of unsound mind? So you abet a person to commit suicide or attempt to commit suicide or a minor or an unsound person, a lunatic. So the Indian Penal Code does not specifically say lunatic. It says unsound mind in this provision. So you force someone to, or you abet someone, or you instigate someone to commit a suicide. So this provision comes under section 306, 305, 302, or 307. So this is under section 305 of the Indian Penal Code. Okay. 306, it deals with abatement of suicide generally. And 305, it specifically deals with minors and unsound mind people. And 302 deals with murder, the punishment. And 307, it deals with the attempt to murder. Question number 48. Which of the following articles of the Indian Constitution provides protection against arrest and detention in preventive cases? Protection against arrest and detention in preventive cases. Article 19. It deals with freedoms, so not at all. Article 20. No. Article 21. It deals with life and personal liberty. So your correct answer is Article 22. Moving ahead, 49. Under Indian Contract Act 1872, which of the following is a valid contract without consideration? So the Contract Act states few valid contracts without consideration. Which among the following are valid? Agreement in restraint of marriage, agreement to pay time bar debt, agreement in restraint of trade, agreement in restraint of legal proceedings. So your correct answer is option B, agreement to pay time bar debt. Moving ahead to the last question of our series. Question number 50 on your screen. Which of the following principles is related in Hadley versus Baxendale, 1854? So we have various principles like the Carlisle versus Carbolic Smoke Ball Company, Hyde case, Hadley versus Baxendale. So we have various pre-independence principles which enshrine the English law principles, which is incorporated in the Indian Contract Act as well, because the Indian Contract Act is basically a pre-independence act. So, counter offer, assessment of damages, acceptance by conduct, pari delicito. So, our correct answer is assessment of damages. So, Hadley versus Baxendale established the rule for calculating damages for breach of contract, damages that arise naturally from breach, damages that arise from special circumstances known to both parties. Counter offer, which was there in the option, is Hyde versus Wrench. Acceptance by conduct is Carlyle versus Carbolic Smoke Ball Company. Pari delicto is Barrett versus Irwin, as we saw in the previous question. Okay. So just try to remember it. Revising it multiple times will help you remember. And your homework question at the last. Under the Indian Contract Act 1872, an agreement is said to be voidable when it is enforceable by law at the option of one party only. It is enforceable, not enforceable at all by law. It is illegal or immoral. It is expressed in writing and registered. So I want you to reply for this question in the comment section. And a thumbs up for you all who are seeing till the last part of the session, because I find many of the students who watch moving away or distracting themselves by not watching the full session. Only if you watch the full session, you will be able to answer each of the questions which arise in your preliminary examinations. If you skip few questions or if you attend few questions and start doing your own work, then it is of no use for you. See, I am teaching you for a cause. I want you all to be rewarded of some effort which I put into. I teach you for 1 hour for a session or 1.5 hours for a session, and you gain knowledge from it. I'm happy with it. There is no much other great reward for me. Do you get the point? As a teacher with a passion to teach, teachers put efforts. It is the responsibility of you students to make use of it. So, without wasting my time, I would like to go ahead with the answer for the previous question, which was in the homework. So the answer is it is enforceable by law at the option of one party only. So with this, I end part 5 from 201 to 250th question of completing our target of 50,000 multiple choice questions. And stay tuned to our next video to watch the part 6 with a new variety of next 50 set of questions. Thank you and have a nice day.